Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today we're talking about your right to counsel before giving blood in an impaired driving case. Cases that should have gone to the Supreme Court of Canada, but didn't. In the case of Villeneuve, Mr. Villeneuve was involved in a motor vehicle collision. He was alleged to have been driving while his ability to do so was impaired, and a police officer followed him to the hospital. The police officer did not advise him of his right to counsel, saying that he wasn't detained, despite the fact that the police officer remained in the hospital room with him, continued to observe him, watched his blood be drawn, and then later seized that blood pursuant to a warrant based on the information he learned from being in the hospital room the entire time. And because Mr. Villeneuve had never been read his right to counsel, he argued that his right to counsel was breached by the officer's continued presence in the trauma room and not informing him that he was detained and of that right before taking a blood sample. Many years ago, the Supreme Court of Canada ruled that hospitals are not charter-free zones, and police officers are obligated to comply with charter rights, including facilitation of contact with counsel, when somebody is in the hospital. But the court distinguished the Supreme Court of Canada's ruling in that case, finding that it is not required in a circumstance where somebody's not detained and there's merely observation. And this raises very important issues, because it's very easy for an officer to retroactively justify their conduct by saying, well, I didn't consider this person to be detained. I was merely maintaining continuity of them. I had a public safety purpose that I was fulfilling while being in there, instead of actually recognizing that they were conducting a full-fledged impaired driving investigation. And the nuance in how an officer sort of says this evidence at trial is ultimately going to be the significance between whether or not somebody has the right to counsel and doesn't have the right to counsel. And while, of course, cross-examination is an appropriate method for dealing with this, it is not the be-all and end-all. The law should recognize that most people, if they were in a hospital room with a police officer after having been in a serious motor vehicle collision, might think that they are being detained by that police officer and should be given their charter rights according to what their mental state is at the time. Indeed, this was Mr. Villeneuve's argument, that the court essentially missed the point that it's not just whether or not the officer intends to create a detention, but also whether a reasonable person in his shoes would have perceived themselves to be detained. And that can in and of itself give right to the Section 10B obligations on the police. Unfortunately, the Supreme Court of Canada really missed the opportunity to apply very recent judgments that they have rendered in relation to when the right to counsel arises and when detention occurs to a circumstance that is going to be more common than many of the circumstances the Supreme Court of Canada has dealt with. And this leaves a lot of people in the lurch when it comes to their charter rights. Hopefully, the Supreme Court of Canada takes another opportunity to take a look at this issue and to recognize that people who have police officers in their hospital rooms might need some legal advice in that context. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law Corporation. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.